indicating again to me that this is not the same individual. It's a common name. There's 23 people in the counties that surround Orange County, including Orange County, with the name Zenaida Gonzalez. The photo further supports Casey Anthony by her saying, I don't know who that person is. I don't know. And my concern, judges, is that the court allows this amendment to plead this punitive damage claim. The problem is that we're still sort of at the same initial point. We should not be allowing, in my estimation, the civil matter to continue while the criminal case is outstanding, because my client cannot engage in discovery. The case law is clear. She can't be subjected to depositions or interrogatories. And the problem is that the longer that this amendment is out there and that an answer is required and that more discovery is done, she can't answer these questions. She's looking at a lethal injection from the state of Florida. She cannot engage in the discovery process, Judge. And it's my humble opinion, respectfully to Your Honor, that we just simply stay the civil matter until such time that the criminal matter is
You have a motion that you filed to that effect.
I did.
And you are within your right to renew it and bring it to the court's attention.
Okay.
I cannot respond to call it up. I think that the last time that I heard something similar was when we were discussing at the beginning of the year whether or not the deposition of Casey Anthony should be allowed to go forward.
That's correct, sir.
Okay? And at that point, I believe that the facts on the ground may have been different than what the facts on the ground are now. So it is totally up to you if you wish to remove that motion to do so. It is not appropriate for me to respond to it. And at this point, where that's not an issue that has been brought up here for us to consider.
Well, it partially has, Judge, because there was a motion. I'm not sure if it made today's docket. I believe it did, according to the notice of hearing that I got for today, a motion to compel answers to the interrogatory. The court, as you mentioned, in the beginning of January of 2009, sought to have to split the baby, if you will, by saying we won't allow that.
Not splitting any baby.
Well, you said
I was basically following what I thought was a reasonable path so that this case would not be taken to the extreme that it has been taken.
I agree.
And to the extent that basically to allow for cooler heads to prevail, to allow for thoughtful processing of the questions and enlightened responses where those were appropriate. That was what was behind the court. I'm sorry if I was a bit naive, but I have every right to expect nothing but the best from everyone.
Judge, I understand.
And I hope that you will hold me to that.
Yes, sir. But my concern is that it does dovetail into the issue of the pending civil matter, because interrogatories, were propounded by Mr. Mitnick. We answered. We invoked our fifth. As I told Mr. Mitnick we would, as I telegraphed to the court in my previous pleading that we would. Mr. Mitnick has now filed a motion.
I would hope that you didn't just respond automatically, but that each and every one of the questions that were propounded were thoroughly thought of and were considered before the responses were put together.
We were, Judge, but the problem that creates, and the problem I had with the court allowing for interrogatories to go forward is this. It's a bit of a trap from the standpoint that you can't pick and choose the answers that you want to give to an interrogatory. Because if I answered, let's say there's 20 questions, Judge, as I recall. Let's say I only answered 7 of them, and in the other 13 I invoked her fifth. Mr. Mitnick could very accurately, I think, and legally come before you and say, Judge, he can't pick and choose what he answers. He's now opened the door to the discovery process. I felt the more judicious way to do it, the more legal way to do it, the way that is buttressed by the case law of the Fifth and of the Fourth DCA, was to answer her name and to invoke her fifth. So I did not have that issue. Because Mr. Morgan's gone any number of times and says, if she will just say, this is not my client, we'll dismiss the matter. I've yet to see that in writing, Judge, so I've been reluctant to do that.
Well, you can't believe everything you see on top.
No, of course not. No, of course. Certainly not in this case, sir.
Judge, I hate to interrupt, but may I say something? First off, the motion that he's talking about to compel isn't called up today.
That's right.
So I'm ready to argue it because I do think they did a blanket. I totally disagree with the position that if they...
And let me rule on the motion that is before the court. And at this point, I will grant the motion to file an amended complaint, and I believe the law requires me, based on what I have read in the file, the depositions, and the content of what's in there, I have to allow you to assert a request for punitive damages. I think that's what the law requires. I'm ruling basically simply on the law and understanding that many of these issues are jury questions.
And just for the record, I would object to Your Honor allowing that.
Absolutely.
Absolutely.
Absolutely. I mean, the fact that you have made the record that you have is objection in and of itself.
Yes, sir.
I think we recognize that. Anything further at this time, or shall we adjourn until Thursday?
I have further,
I
but we'll
believe
take it up Thursday.
somebody wants to say something? Co-counsel? Now, here's one of the things that I am going to caution against. The last time that we gathered in court, it was very difficult, and I believe that there may have been a security issue. The way that folks gathered outside and did not leave the courtroom corridor open for folks to exit the courtroom. The courtroom wound up open because the media and the cameras were right outside, getting everybody as they went without allowing the court doors to close. If there is a continued interruption, and if there's a continued security issue where the court's not allowed to close its door, because it's more important to get the people coming out of the courtroom, then what we'll wind up doing, if that continues, we will go ahead and request that the media do their interviews downstairs and not outside the courtroom doors. So please govern yourselves appropriately and at least provide, even if it's just the minimum amount of respect due to the courts, to make sure that folks are allowed to leave and that you do not create a security problem by providing an obstacle to those who wish to leave. I know that there are certain lawyers that are going to be expected on the 11th floor since their cause has been delayed, and I expect them, I'm going to ask that you might wish to start down now. So, anything else to clarify the ruling of the court?
Will they have 20 days to respond?
They will have 20 days to respond or to file whatever other appropriate motions or documents they deem is appropriate. Counsel?
Judge, the only thing I would say, if I can just add one thing, is I drove up from Fort Lauderdale yesterday afternoon. It would have been nice. I know Your Honor is very big on professionalism. For the other side, they've called me and say, hey, we're going to table X motion, but we're only going to go on Y.
Yeah, all right. That would have your approach, please.
Okay.
Oh, no, it's all right.